Good afternoon, everyone. My name is 𝗦𝗲𝗿𝗶𝗆𝗆. I am a PhD candidate in the Department of Anthropology at the University of New Mexico. And I am speaking to you from Albuquerque, which sits on unceded indigenous territory and among the traditional homelands of multiple sovereign nations, such as the Pueblo, 𝗷𝗍, and the Apache peoples. On behalf of the Department of Anthropology, the Alfonso Ortiz Center for Intercultural Studies, and the Latin American and Iberian Institute, I would like to thank you for joining us today. This talk is part of the 2022 Spring Anthropology Colloquia Speaker Series. Now we will hear from Dr. Les Field, Professor of Anthropology here at UNM, who this semester is facilitating a class titled Colombia in War and Peace.
Thank you very much, Pilar. It's a great pleasure to be here and to welcome Professor Lyons to our colloquium series. Our colloquium series features current research in all of the subfields of anthropology in our department, and we utilize it to reach out to a wide range of topics and researchers and to educate ourselves, our students, our faculty on topics that are of great importance to us. Today's topic is of great importance to me. I'm a Colombianist scholar. I've worked in Colombia in the Departamento de Cauca since 1989, and I have greatly benefited from colleagues in Colombia and here in the United States who focus on topics. I just got Dr. Lyons' book today, so I'm reading it. It's a fascinating portrait of her work in the Departamento de Putumayo, which many of us came to know well through the work of a Colombian scholar, Clemencia Ramirez, who is also cited extensively in Dr. Lyons' book. I'm really happy to see her work and to see how young scholars are reconceptualizing, bringing in new theoretical foundations and theories to think about the very, very complex situation that we see in Colombia, in the world today. I just noticed that our colleague Joanne Rappaport has joined us, and I'd like to honor her as one of the great scholars of Colombia, honored in both Colombia and here in the United States. So what a pleasure to have such an audience for today's talk. And so thank you for coming, Professor Lyons. We're really interested in what your work is teaching us and what you will have to say today.
Thank you, Les, and yeah, welcome, Dr. John Rappaport. Now I would like to introduce today's speaker, Dr. Kristina Lyons, Assistant Professor of Anthropology at the University of Pennsylvania's program in the Environmental and Humanities. She received her PhD in anthropology from the University of California, Davis in 2013. Dr. Lyons' current research is situated at the interfaces of socio-ecological conflicts, transitional justice, community-based forms of reconciliation, science studies, and legal anthropology in Colombia. Her research has been funded by the Rachel Carson Center for Environment and Society, the Fulbright Program, the Wenner-Gren Anthropological Foundation, the Social Science Research Council, and the Colombian Ministry of Culture, among many others. She has been awarded the Cultural Horizons Prize by the Society for Cultural Anthropology and the Junior Scholar Award and Roy A. Rappaport Prize by the Anthropology and Environment section of the American Anthropological Association. Dr. Lyons has published many articles in cultural anthropology, social studies of science, city, and society, and the Journal of Latin American and Caribbean Anthropology, among other venues. Her book, Vital Decomposition, Soil Practitioners and Life Politics, published by Duke University Press in 2020, was awarded the honorable mention by the Bryce Wood Book Award from the Latin American Studies Association. And it was also published in Spanish in 2021 by the Editorial Universidad del Rosario, Colombia. Dr. Lyons has collaborated with the Constitutional Court of Colombia, the Office of the Inspector General, the Center for the Studies of Law, Justice, and Society, the Alexander von Humboldt Biological Research Institute, the National Center for the Historical Memory, and the Foundation 𝗏𝗏𝗏, among other organizations and institutions in Colombia. She also participated in the 2016 Monsanto Tribunal in The Hague regarding the use of glyphosate in the US-Colombia war on drugs. In 2021, she was awarded a Fulbright Award to support the work of the Special Jurisdiction for Peace in a case with local communities in southern Colombia to reconstruct the socio-environmental memory of the war. Today, Dr. Lyons will share with us her research on the growing legal recognition of nature and territories as casualties of war in Colombia's transitional justice process. So now I'd like to invite you to give a warm welcome to Dr. Kristina Lyons.
So thank you so much for the really wonderful and generous introduction, Pilar, and also Les, and thank you to the Department of Anthropology and the Alfonso Ortiz Center for Intercultural Studies and the Latin American and Iberian Studies Institute for the invitation to be part of the series. And a special thanks again to Pilar for all her organizational assistance setting this up, and to all of you in the audience for joining the conversation today. So as Pilar mentioned, my talk today is entitled Nature and Territories as Victims in Colombia's Transitional Justice Process. And I'm going to share my screen for a minute to get started with the presentation. So I'll just begin. So during a public talk in March 2021, Justice 𝗭𝗶𝗂𝗋𝐶𝗾𝗏 explained, there's a tremendous need to have a diverse range of judges seated on the country's Transitional Justice Tribunal, with different modes of thinking from different regions with distinct experiences, profiles, and challenges, but that are all thinking with La Colombia Profunda, La Colombia Más Excluida, the deep Colombia, the most excluded Colombia. The talk was organized to discuss the innovative work of the Special Jurisdiction for Peace, or the 𝗏P in Spanish, regarding its legal recognition of nature and territories as victims of Colombia's near 6-decade armed conflict. The 𝗏P was established as the extrajudicial court system mandated to administer transitional justice and uncover the crimes committed between January 1st, 1990 and December 1st, 2016, when a peace agreement was signed between the national government and the longest-running guerrilla organization in the Western Hemisphere, Revolutionary Armed Forces of Colombia Popular Army, or the 𝗏ARC-EP. How does one construct what in Colombia we refer to as paz territorial, territorial peace, the judge asked, referencing a notion that appears in the final accord of the country's peace agreement. For the first time, the territorial dimensions, specifically the spatial tensions and processes of appropriation and dispossession at the core of the country's violence, were not only explicitly referenced by both the state and the 𝗏ARC-EP as a central problem that needs to be addressed, but also considerable thought was dedicated to what territory signifies for a diverse range of actors. I think this construction begins when we start to change paradigms, when we open our mentalities to other ways of knowing, doing, feeling, and thinking, to rural worlds and collective subjects with special constitutional protections, Judge 𝗏 told the audience. Judge 𝗏 was born in 𝗏𝗏𝗏𝗏, the political and spiritual capital of the Arhuaco people located in the Sierra Nevada of Santa Marta in Colombia. In 2014, she became the first indigenous auxiliary judge of the High Council of the Judiciary in Colombia, and in 2018 began serving as a magistrate for the Chamber for the Acknowledgement of Truth, Responsibility, and the Determination of Facts and Conduct of the 𝗏AP. Mamos, spiritual leaders of the Sierra Nevada, insist that the repeated aerial fumigation of their ancestral territory with Monsanto's glyphosate by militarized anti-narcotics operations during the armed conflict not only caused environmental damage, but also damaged and reduced the vital energies of the mountains, lagoons, stones, and animals that is reflected in an increase in diseases among humans. These same soils impacted by fumigation may also be riddled with landmines. Rural families recount memories of their children filing cautiously to school so as not to stray from well-visible footpaths. They narrate incidences of blown up cows, dogs, and horses, changes in practices of hunting, fishing, and farming, general confinement, lingering fear, and the number of human casualties and maimed bodies. Indigenous communities in particular have placed special emphasis on their restricted ability to visit sacred sites and the spiritual imbalances produced not only by the continued presence of unexploded landmines, but also of mass graves on their lands. Such experiences of violence form part of the concerns that 𝗦𝗲𝗍𝗫𝗀𝗀 has brought to the courtroom. The HEP is currently charged with investigating and adjudicating 7 macro cases, and this talk is based on over 12 months of fieldwork accompanying 𝗦𝗲𝗍𝗫𝗀𝗀's chamber in the investigation known as 02, that incorporates social environmental destruction and territorial harms. 02 is one of the 3 territorial cases that emerged in response to indigenous, Afro-descendant, and campesino organizations who requested that their territories be recognized as direct and indirect victims of the armed conflict. Their request was based on the argument that their territories are living beings with an identity and dignity that constitutes them as subjects of rights. By adjudicating these cases, the HEP is having to grapple with multiple conceptualizations of territory as they are operationalized to interact with institutionalized legal paradigms that seek to both punitively sanction and provide restorative justice options. Such concepts may include territory as a delineated area of collective property and quantity of land, a living being and sentient force, a spiritual guardian, a source of material sustenance, and a mode of knowing, being, governing, and belonging. In this talk, I build off of conversations in cultural anthropology, environmental humanities, and critical justice studies to discuss a series of tensions and opportunities that emerge within a juridical solution that is rooted in a liberal humanist conception of rights, as this solution interacts with comprehensions of more than human victims. This work is important because it invites us to think deeply about the possibility of justice within the uneven conditions of more than human livability in war-torn worlds. It contributes to discussions about the stakes of the promise of justice as never perfect, always in becoming, performative and pragmatic, involved in a continual process of questioning. I argue that these more than human victims are both nature and territory, and hence never fully comprehensible as either nature or culture, secular or spiritual, objects or subjects, crimes or harm. Some territories in Case 02 are constituted by relations with chagras, or indigenous agricultural spaces, spiritual ancestors, traditional authorities, and the balance of harmony between various planes of existence. Others are based on relationships with rivers, fishing, artisanal gold mining, and ancestral funeral medicinal practices. A number are characterized by juntas de acción comunal, the central social organization of peasant communities in urban neighborhoods, hectares of farmland, and the circulation of curative secrets. While other territories are defined by neighborhoods, relations with mangroves, and rooted in ancestral memories of palenques and cimarrones, or social and spatial configurations organized by Afro-descendant peoples who escaped enslavement. Violence that affects the possibility of maintaining spiritual harmony, practicing funeral rituals and traditional medicine, traveling the rivers and walking the land, engaging in farm work, fishing and collecting from the roots of mangroves, not only harms the lives of human communities inhabiting these territories, but also affects the lives of territories. The exceptional nature of transitional justice unsettles the traditional paradigm of state sovereignty and the rigidity of the conventional sources of law. Colombia's constitutional regulatory framework is changing as the country allegedly transitions into a post-peace accord scenario. The traditional paradigm of law is also unsettled by the HEP itself as a unique institutional mechanism intended to fix the process of national political transition according to the obligations contained in international law, in particular in regards to protecting human rights against illegal state actions and guaranteeing rights to access justice. What does it mean to have both victims in the state in transition simultaneously for the judges and officials who are attempting to piece together patterns of crimes when indigenous, Afro-descendant, and campesino communities may understand more capaciously in terms of harms? What conceptual and methodological tensions emerge in transitional justice frameworks when these popular and ancestral understandings of victimized territories are placed in dialogue with the conventions of international law and emergent rights of nature frameworks. The temporary configuration of state sovereignty both obliges and creates opportunities for the 𝗵 to implement constitutionally recognized legal pluralism in its differential approach to group of human victims, in its engagement within this multiplicity of justice-making practices that are ongoing and essentially rooted in their territories. 𝗏𝗏𝗏 distinguishes these concepts of pluralism, calling the former state legal pluralism and the latter community legal pluralism, to refer to the spaces formed by social forces and collective subjects with identity and autonomy, subsisting independent of the state. Thus, the emergence of a transitional justice process, which in itself signals a total failure of the state to enforce law through domestic justice mechanisms, is mandated to interact with derecho propio, or customary law, that is not only a source of state law, but also a coexisting legal system that can even be applied against state law. The demands of indigenous, Afro-descendant, and campesino organizations that their territories be recognized as victims are positioning territories as agentive in ways that broaden previous understandings of economic violence and natural resource disputes, which currently undergird the field of transitional justice, post-conflict discourses, and peace-building studies. These cases also offer important nuances to debates among scholars, legal practitioners, and activists about the mechanisms of representation through which quote-unquote nature can be brought into legal standing. By focusing on the ontological openings and empirical tensions produced in the interactions between diverse victim organizations and 𝗵 officials, I demonstrate a series of decolonizing moves that may be destabilizing the supremacy of liberal law by unsettling conventional juridical categories of legitimacy and ways of knowing and being. Specifically, the 𝗵's territorial cases complicate prevailing characterizations of the encounters between plural realities and jurisprudences as examples of hybridity and coordination. These attempts to decolonize liberal law embody both radical transformative potential and incompleteness. This potentiality and partiality are continually negotiated by those like Justice 𝗖𝗍𝗏, who are rooted in their obligation to apply the dominant principles of international and constitutional law, while at the same time being tasked with bridging ontological incommensurability between unequal legal systems. All this while interacting with the realities that these jurisprudences defend as world-sustaining practices and autonomous exercises of derecho propio. These judges' differential, what some might call progressive, positions within the tribunal, is constrained by the colonial legacy of law, in addition to the violence being perpetuated in post-peace accord of Colombia. In what follows, I analyze how concepts of territory informing the 𝗵's investigative process both build upon and challenge the frameworks of what many consider to be the most radical environmental rights today, rights of nature decisions, that grant legal personhood to specific bodies of water, ecosystems, national parks, etc. I describe the way the tribunal's judges and bureaucrats hold multiple concepts of nature, territory, crime and harm, and friction, as they attempt to broaden juridical categories of victimhood to expand the anthropocentric and secular categories dominant in international law. Next, I elaborate on the ontological nuances that exist between local communities' different understandings of territory, and the 𝗵's attempt to broaden comprehensions of this concept beyond the essentialist constraints of multicultural frameworks. Last, I briefly reflect on the ethical political implications of the presence of historically marginalized peoples and the life worlds they form part of among the country's transitional justice tribunal. While postmodern views of law have relied on legal pluralism, or what Santos called interlegality, as a key concept to explore the coordination and clashes between legal orders, the ongoing work of the 𝗵 invites attention to attempts to decolonize the dominant frameworks of both environmental and international law. Before I continue, I just want to make a brief note on fieldwork. My invitation to collaborate with the 𝗵 was based on almost 2 decades of fieldwork with communities inhabiting the epicenters of violence in southern Colombia, and the judge's conviction that anthropological insights were relevant for the intercultural and transdisciplinary dialogues organized by her chamber with grassroots victim organizations. My research with 𝗔झિＨ 𝗵𝗶𝗆𝗆's legal team began in June 2020 and was conducted virtually until January 2021, followed by 9 months of fieldwork in Colombia. My role working with the 𝗵 was not as an expert anthropological witness. Rather, I was part of an interdisciplinary initiative made up of lawyers, anthropologists, and environmental and forestry engineers, collaborating to build and implement socio-juridical methodologies for the investigation of more than human victims. The long tradition of anthropological work on law has demonstrated the value of ethnography for articulating the multiplicity of coexisting legal systems and their interconnections within unequal power dynamics enduring structural violence and coloniality. Yet there is significant ethnographic detail that cannot be revealed in anthropological writing, when it is imperative to discuss only publicly disclosable information in order to protect the confidentiality of victims and the integrity of an open juridical case. This situation created clear ethical limits put in place by my interlocutors at the HEP about the ethnographic-based observations that could be revealed in an academic publication or talk. How then does one engage in ethnography of transition? Specific to this talk, of a temporary tribunal in a transitioning political landscape, tasked with investigating crimes against not only human victims, who of course transform and change, but also territories as victims. Within this context, Beal and Locke's provocation regarding analytical openness and the need to empirically attend to the complexity of the unfinished and in flux is of particular interest. Such openness is pertinent not only to the speculative aspect of writing ethnography of transition, but also to the ontological indeterminacy that arises in situations of legal transition, and especially within investigative methodologies as they unfold in open cases. At the same time that the HEP is collecting evidence to prosecute alleged perpetrators, its functionaries are attempting to define who, what is the victim, when this victim is not only human, and its very scale, scope, and being continue to change and are not the same for each group of human victims. The kinds of crimes under investigation, which may be described in terms of degradation, spiritual imbalances, and manifold losses, are simultaneously material and immaterial phenomena in temporal shift. Unlike domestic law, which investigates crimes on a case-by-case basis, the HEP's mandate over the next 15 years is to elucidate, judge, and punish repetitive structures of rights violations or macro-criminal patterns. Focusing the investigation on patterns is a commitment to investigate the design, ideological underpinnings, and execution of the commission of systematic crimes, as well as to focus on the highest criminal responsibilities. This methodology is based on quantitative and qualitative analysis of a configuration of repertoire, targeting, frequency, and techniques through which the violence occurred. In practice, this approach relies on standard truth and reconciliation methodologies, the stringing together of singularizing victimizing acts, naming of names, articulating chains of causality, and revealing public secrets. HEP officials examine human rights reports, news releases, published data sets, and information produced by state entities, NGOs, academics, corporations, and largely the testimonies of human victim organizations. Following this method, the criminal patterns of social environmental destruction and territorial harm that might be investigated in the context of Colombia's armed conflict include illicit use and impacts caused by landmines and explosive remnants of war, impacts of illegal and criminal mining, effects of aerial fumigation with glyphosate during the US-Colombian War on drugs, and attacks made against oil infrastructure, contamination caused by spills, and illegal siphoning. Early on in my interaction with the 𝗔𝗫𝗁𝗏𝗏's legal team, I reviewed the genealogy of international law to better understand what is theoretically protected in times of war and the empirical challenges involved in extending victimhood status to what this legal framework refers to as the quote-unquote non-human environment. The convergence of two trends over the second half of the 20th century, global environmental awareness and advances in military weaponry, including environmental modifying techniques such as defoliation, rainmaking, and massive plowing, caused citizens and tribunals to reflect on the existing legal deficiencies of protections for victims. These concerns inspired a string of environmental shielding international conventions after the Second Indochina and Vietnam Wars. Despite advances in the recognition of the environmental devastation and material and immaterial damages of prolonged mass violence, the structures of international law have made it difficult to expand relatively narrow categories of victimization. These challenges range from issues around establishing culpability and causation to the lack of methods for evaluating environmental damages or assessing military justification and advantage, to political resistance to expanding individual accountability beyond 4 core crimes. The core crimes currently recognized by the International Criminal Court are genocide, crimes against humanity, war crimes, and the crime of aggression. Moreover, most of these international legal norms lack applicability in context of internal armed conflicts. The 𝗵's accreditation of specific territories as victims builds upon a body of domestic law anchored in what is known as Colombia's 2011 Law of Victims for Indigenous Communities, which first acknowledged territory as a living integrity that suffers harm when violated or profaned by the internal armed conflict. In this law, spiritual healing is considered part of the integral reparation of a territory. Both this decree and the 𝗵's legal orders rest on concepts of spirituality incorporated into a number of international laws and treaties protecting the rights of indigenous peoples. Centrally, this spirituality is understood as being maintained through relations with an array of other than human participants who are sentient beings endowed with particular dispositions, desires, and effects. In 2019, taking inspiration from its own legal orders, the 𝗵 published a press release acknowledging the environment as a quote-unquote silent victim of the armed conflict. During her public talk in March, 𝗭𝗫𝗫𝗀𝗀 clarified that the tribunal refers to victims who have been silenced due to the domestic legal system's inability to register, perceive, or hear them, and not representations of nature as a mere inert or passive backdrop. Since 2016, the country's courts have ruled in favor of a series of rights of nature legal decisions. These rights of nature rulings directly clash with the national extractivist development model, ongoing colonial legacy of extreme land concentration, and continuing violence against social leaders, environmentalists, and former combatants. Such apparent contradictions provoke serious questions, given the expectation that the priorities of victims are meant to be at the center of every stage of transitional justice interventions. Of particular interest to this talk, the empirical methodologies of investigation, intercultural dialogues, and legal constructs that may emerge when justice for more than humans and the relations making particular humans and other than humans is at stake. Nature is not necessarily territory. Crimes do not necessarily address harms. Nature is not necessarily territory. It is crucial to understand territory in many dimensions that are not only physical, and from a logic that is both individual and of collective interest. 𝗭𝗫𝗫𝗀𝗀 explained during her public presentation in March. For example, in indigenous jurisprudence, there are no separations. Law does not exist versus education versus health. Knowledge is territorialized. It is the life conditions, the spiritual and cultural life of collective subject that is being limited, even exterminated, she said. The judge went on to argue that the recent increase in rights of nature rulings among the country's tribunal demonstrates a certain level of awareness about protecting parts of nature that provide services to the human population. Further, several of these decisions, especially the groundbreaking 2016 Atrato River and subsequent rights of the Amazon rulings, have sought to advance the emerging field of biocultural rights, which are intrinsically linked to the ancestral practices of local communities, their territorial roots, perceptions of their life worlds, and respect for reciprocal relations with nature that provides for their daily sustenance. She acknowledged the importance of these decisions in terms of their extension of legal personhood to what were only recently understood to be objects, resources, or property, and also in their potential to buttress her chamber's attempts to broaden public perception and juridical concepts of victimhood within the constricted categories available in international law. Even though rights of nature rulings can serve as legal tools in the investigation of territories as victims, this does not include the fact that local communities' differential relations with their territories may exceed Western conceptions of nature, which remain tethered to natural resource and ecosystem service frameworks. Similar to the judge's description of territory, Native scholars have discussed the way land refers not just to materiality, but also includes the spiritual, emotional, and intellectual aspects. Indeed, during her talk, 𝗭𝗫𝗫𝗀𝗀 troubled questions of agency and representation that have been central tensions in global rights of nature debates. She explained to the audience that in her Arawakan upbringing, the territory is alive and responds. The territory is consulted in justice matters. To exemplify this, she narrated a story told to her by a mamo. When all was dark and plants and animals were people, these beings first made the ancestral norms and customary law, which in the dawning was passed on to humans to fulfill in their modes of inhabiting and caring for territory. Her brief illustration of territorialized knowledge demonstrates how plants, non-human animals, stones, bodies of water, and other beings are the makers of the law that must be respected, ethically and reciprocally maintained by the human community inhabiting a given place. The question of who should speak on behalf of indigenous territories as victims was clear to the judge. She argued for that for these communities, traditional authorities, the entrusted spiritual leaders of each community, are able to consult these territories in justice matters. When the institutional mechanisms of transitional justice, with their scientific and legal apparatuses, investigate territories as victims, they are expected to dialogue with these place-based modes of expertise and ontological mediation. However, prior attempts at this process, which she called intercultural dialogue, had not been particularly successful in the ambit of domestic law, making the 𝗵's territorial cases potentially transformative and yet also very difficult. It demonstrates how the investigative practices of 𝗭់•𝗫𝗫𝐶𝗵𝗆 chamber might constitute a decolonial move in the legal frameworks guiding rights of nature cases in Colombia and broader biocentric legal terms in the Andean region, especially when these decisions have been critiqued for failing to acknowledge their philosophical indebtedness to the ancestral knowledges of indigenous peoples, and even worse, when they end up excluding local communities from foundational roles in the same rulings involving the protection of beings, territories with whom they're intimately connected. In contrast, the 𝗵's accreditation of 𝗬 communities as in 𝗏𝗏, Grand Territory 𝗬, as victims in case 02, explicitly states that this identification is the product of longstanding indigenous activism. It positions the 𝗬 as not simply beneficiaries of a well-intentioned tribunal or as victims, but also protagonists in creating their own relationship to the state through the autonomous practice of derecho propio. When 𝗵 officials use techno-scientific forms of assessing the contamination of a watershed after recurrent explosions of an oil pipeline or illegal mining operations, they rely on evidence provided by community experts. These experts may consult a living being who manifests the consequence of disrespect for its laws through spiritual imbalances, disharmony, unexplained illnesses, and unstable temperament. The harms that result from these infractions are both a product of and exceed the eventfulness of the criminal act of detonation. Concepts such as slow violence and latency have helped render the representational challenges of complex spatio-temporalities of environmental crimes visible and thus actionable among activists and in terms of broader justice struggles, both within and beyond tribunals. Crime is most frequently conceived of as a legal construction dependent on its geographic, temporal, and institutional defined contingents. One example is that in order to produce the Colombian armed conflict as an investigatable event, human rights organizations are asked to omit rights violations that continue to occur and extend beyond the cutoff dates for the mandate of the 𝗵. And this in turn undermines narratives of post-conflict and guarantees of non-repetition of violence. Speaking of harm rather than crime marks a significant shift in orientation, similar to Deborah Thomas's attention to repair rather than reparation in her analysis of contemporary state violence in Jamaica. Repair, she argues, is practice-oriented and quotidian. It is non-eventful and deeply historical and relational. Parallelly, the embodied, multi-scalar, collective and ongoing way that each human victim organization defines harms to their territories overlaps with, but also exceeds a logic of crime. The recognition of sentient territories as victim poses particular challenges to what borrowing a concept from Adriana Petrina I call the horizoning work of 𝗵 legal teams, who must identify criminal patterns while cognizant that their juridical, perceptual, and ontological limits are being pushed upon by phenomena beyond their knowability. For these officials, unknowability arises not only from the difficulty for local communities in prioritizing victimizing acts, clearly identifying responsible parties, and locating the precise dates and locations of socio-environmental destruction for which there are no baselines. It also has to do with the different kinds of relations cultivated by indigenous, Afro-descendant, and campesino epistemologies to what is knowable than those stressed by Western law and positivist sciences. The active acknowledgement of what 𝗫𝗫𝗍𝗫𝗍 calls an epistemology of unknowability necessarily requires openings in the distribution of the sensible towards relations and entities that members of the 𝗵's legal team may be unable to know, but that are nevertheless actors and victims in the investigation process. Consulting the territory in justice matters, in the words of 𝗭់•𝗫𝗫𝗫𝗫, may resemble what 𝗏 and Todd call a kin study approach, rather than environmental case study method frequent in the natural sciences and environmental law, which they argue tend to insert separations between place, thought, and relations. The judge differentially described this inseparability in terms of the indivisibility of indigenous peoples and their territories, the biocultural relations that make Afro-Colombian experiences of place, and the special territorial relations that campesinos also cultivate. None of these descriptions relied on human subjects who are rights-bearing subjects isolated from a continuum of being and elements upon which their lives depend and with whom they may be intimately related. These relations complicate legal constructs of the intrinsic value of nature and the protection of ecosystems from human activity that dominant conservation strategies and certain rights of nature rulings legally establish. When the judge explicitly referred to the challenges of comprehending the situated ways that each human victim organization understands socio-environmental destruction and harms to their territories, she must hold multiple concepts of nature, territory, crimes, and harm in frictive tandem. Some communities may experience crimes to nature that is closer to Western understandings of ecosystems. Others may make reference to a sentient being they call territory, while others may simultaneously relate to concepts of nature and territory, which are not only one or the other. Controversial questions are embedded in these nuances regarding urban, peri-urban, and campesino populations who are not considered to have particularly spiritual, collective, or customary claims to place. Even though they share similar experiences of social exclusion, agrarian-based violence, and impacts of decades of armed conflict, these social groups were not granted distinctive rights or special protections in the country's 1991 multicultural constitutional reforms, or the 2011 Victim Law, which aspired to guarantee the cultural integrity of indigenous and Afro-descendant communities. Political and ethical debates continue to exist surrounding the way actual and shifting legal definitions of territory perpetuate asymmetries in the distribution of vulnerability among rural communities and urban dwellers. Thus, beyond the complexity of investigating territories as victims, where there are no fixed class of ethically relevant beings or fixed degrees of sentience, aliveness, the decisions of the HEP chambers are also troubling the essentialisms underlying multiculturalist ideas about which human groups are assumed to have claims to territory, territorial modes of belonging, and which others are excluded from this category in rights-based framework. The traditional justice process cannot generalize when it declares territories as victims, Judge Izquierdo reiterated several times during her presentation. How can we materialize these differences, she asked, sharing a concern with the audience faced by HEP justices and officials. Comprehensions of territory beyond multiculturalism. In macro case 02, the Chamber for the Acknowledgements of Truth, Responsibility, and the Determination of Facts and Conduct of the HEP accredited 32 indigenous 𝗏𝗏 communities in 𝗏𝗏𝗏, Grand Territory 𝗏𝗏, as victims. 𝗏𝗏𝗏 as a living being is distinct from 𝗏𝗏𝗏𝗏, the territory of 𝗏𝗏𝗏𝗀𝗏𝗏 indigenous communities, also participating in the case. Relations within concepts of territory for the 18 consejos comunitarios or Afro-descendant populations recognized as victims are understood and lived differentially than for urban Afro-Colombians now located in the peripheral neighborhoods of the city of Tumaco, many of whom were forcibly displaced from their collective rural lands during the armed conflict. In addition, the accredited campesino organization also has particular identifications in territorial-based modes of belonging. All of these territories and the multiplicity of socio-ecological relations that make them simultaneously form part of and exceed a quantitative reference to the 743,000 hectares of land prioritized by the HEP in the municipalities of Tumaco, 𝗏𝗏𝗏𝗏, and 𝗏𝗏𝗏𝗏𝗏, Nariño, 78% of which legally belong to indigenous and Afro-descendant communities. Their status as victims also exceeds the 105,205 human victims who form part of the case, and whom would normally take precedence within the conventional frameworks of international law. Neither can territorial modes of belonging be defined solely in terms of the delimited hectares of land occupied or partially used by state-recognized indigenous and Afro-descendant ethnic groups in what since 1994 have been called campesino reserve zones that legally allow for the defense of peasant territory. As Judge Izquierdo asserted, the justices and officials of the HEP are aware that territories as victims must be situated in their partial connections between human organizations of victims and also in their ontological specificities. The judge explicitly distanced her thinking from what Arturo Escobar calls mono-ontological understandings of the world, that as understandings that refuse a multiplicity, or in his terms, pluriversality, of ways of both articulating and coming into relation with diverse social natures. For Chambers' decision to broaden legal understandings of territory to incorporate campesino organizations that have historically been tied to ideas of household-level land-based agrarian livelihoods, and to also include internally displaced rural peoples who are now residing in urban areas, are, I suggest, another example of a decolonizing move. Specifically, an attempt to address the divisive consequences of what many consider to be the progressive winds of liberal multiculturalism, which granted legal recognition and special protections to specific enactments of indigeneity and Afro-Colombian identity, while also weakening the political alliance building capacity between these groups, campesino organizations, and other rural and urban sectors. Notwithstanding significant social scientific interest in the study of peasants, this category has remained academically and legally bound to more static, land claim-oriented identities defined according to the state and capital. The Chamber's choice to accredit campesinos comes in the wake of more recent struggles to politically and legally problematize this category in and beyond Colombia. The HEP's legal decision is controversial, given the range of territorial disputes that may exist between heterogeneous indigenous, Afro-descendant, and campesino communities, along with the divisions between rural-based groups with rights to collective territory versus their urban, poor, indigenous, and Black counterparts. It also runs contrary to the national government's failure to ratify the 2018 UN Declaration on the Rights of Peasant and Other People Working in Rural Areas that would protect campesinos and rural people's rights to land, autochthonous seed systems, food sovereignty, and more broadly, provide them with political recognition. The HEP's macro-territorial cases demonstrate the need to both prioritize the particularities of indigenous peoples' territorial relations and ancestral origins, while also acknowledging the complex temporalities of dispossession and variations of justice existing in a given place. This is especially true in situations where many settlers came to recently occupy already colonized indigenous lands through processes where they were also brutally uprooted and forcibly subjected to violent territorial reconfigurations. Additionally, rural communities and displaced to urban peripheries who have physically lost their territories remain rooted in territorial knowledges and practices. 𝗏𝗏𝗏 introduced the idea of an ecoterritorial term to refer to a new political grammar informing social environmental struggles throughout Latin America, which complicates urban-rural dichotomies and isolated analytical treatment of agrarian and environmental problems. This mobilizing shift is especially relevant to a country whose agro-environmental issues are at the root of decades of armed conflict and ongoing violence. Beyond the imperative to construct criminal evidence, other possibilities may emerge during the dialogic spaces organized between HEP officials and members of indigenous, Afro-descendant, campesino, and urban-based human victim organizations. Specifically, conversations to deal with the continued conflicts that may be affecting the relationships and conviviality between these communities, their modes of territorial ordering, and urban-rural dynamics. The Chamber's recognition of the multiplicity of territories existing within the parameters of Case 02, along with diverse victim organizations' recounting of the harms experienced by their territories and communities, could also lead to transformative reconciliatory strategies that extend beyond the mandate of the tribunal and what it calls the future tasks, works, and activities with reparative content or tours that will result from the case. In this way, the Chamber's investigative process may also create possibilities for what Papadopoulos calls worlding justice, that does not only defer justice to the need for verification, periods of proof, or external rulings. Such autonomous ancestral justice practices, such as you see in this photo, where a campesino family is reforesting area that was fumigated by glyphosate and was before that previously cleared for monoculture cocoa cultivation. So they're reforesting this on their own initiative. Are practices that not only dialogue across ontological difference, but they're already addressing harms that occur between neighboring communities when these human victims participate in the investigations of the HEP with the hope of revealing truth and righting some profound criminal wrong. This reminds us that even when justice-seeking aspirations are situated in juridical-based solutions and administrative mechanisms, they are never only captured by the liberal underpinnings of what the law can perceive and hence sanction in or attempt to restitute. The identification of crimes does not fully encompass what it means to address harms, just as HEP justices are implying international law, yet also doing more than this. Of the 51 HEP justices, over half are women. Over 10% identify as indigenous and over 10% as Afro-descendants, and a majority are from outside the capital city of Bogota. The decision of the ethnic chamber of the country's peace accord that was led by Afro-Colombian leaders, indigenous authorities, and grassroots victim organizations lays out a transversal set of principles which guarantee that the entirety of the accord should be implemented with a differential focus in the participation of these communities. Given this differential commitment, the composition of the tribunal must necessarily reflect the diversity of rural worlds, collective subjects with special constitutional protections, and historically marginalized peoples, in order to guarantee access to justice to social groups for whom this right has been systematically and historically denied. However, rather than relying on legal anthropology's concepts of hybridity and coordination to describe the encounters between multiple jurisprudences, the work of the 𝗵, I argue, warrants consideration of the more radical potentialities produced by the composition of its tribunal and the life worlds being prioritized in its territorial macro cases. Specifically, what occurs when historically marginalized peoples occupy institutionalized spaces that defend international law, if we understand this system to be shaped by the 16th century colonial encounter between the Spanish and indigenous peoples of the Americas. The inheritance of this legal system gives the 𝗵 legitimacy to politically constrained state actors, while fixing the country's process of political transition according to the obligations contained in the liberal framework of international law. At the same time, the tribunal interacts with the jurisprudences of derecho propio that have been recognized by the multicultural state and attempts to redress ongoing colonial wrongs. From 𝗔릿𝗁𝗵𝗃𝗫's perspective, a paradigm change is taking place in the 𝗵 that resembles Spivak's call for a change to be made in the conditions of being heard. More specifically, so that conditions to be heard are no longer set by those who construct the dominant liberal humanist frameworks, informing not only what and who is a victim according to international law, but also Western concepts of nature still prevalent in environmental legislation. I understand the attempts to decolonize the investigative methodologies of the 𝗵 to be processual and incomplete, in part because justice is always already a failure and thus escapes and disappoints both those who seek it and those who are charged with its implementation. Being in the presence of 𝗵 justices and listening to the testimonies of human victim organizations resonates with Diane Nelson's analysis of the impossibilities of reparation in post-war Guatemala. Quote, looming behind each singular loss and even the aggregate of genocide is an older colonial imbalance, so that there can never be a fully adequate repair. This said, Nelson goes on to write, but you cannot not ever give up on something that might be called justice. If we heed abolitionists' call not to fall prey to the desire to perfect the jury, the judge, or the jail, then we must be willing to think about justice from impurity, or a both and, not only approach. I situate the work of 𝗵 justices and officials by taking inspiration from Max Liboire's discussion of methods for practicing dominant scientific research paradigms, while responding to the incommensurability with indigenous sciences and knowledge systems. 𝗵 justices are rooted in their obligation to apply the dominant principles of international and constitutional law, at the same time that some are also attempting to decolonize aspects of these same systems. Negotiating ontological differences is not necessarily a new role for them within the official multicultural politics of the state. Kim Thalberg points out that calling non-indigenous peoples into strategic alliances and even kin relations as a diplomatic strategy has existed among the practices of indigenous peoples since colonial encounter. In the particular case of the 𝗵, female indigenous and Afro-descendant judges are officially tasked with engaging in this political and relational work, while also obliged to defend the legally binding agreements of a liberal international legal system embedded in its ongoing colonial legacy of dispossession and amnesia. Each progressive legal decision is but a patchwork recovery of what already was and still is for many indigenous, Afro-descendant, and campesino communities, and their autonomous governance and collective care of their lands and territories. 𝗵 justices not only positionality results in what Van Doren calls an emergent ethics, rather than a merely applied one, in which decisions must be taken even when there is never a satisfactory situation in which justice will ever be completely materialized, impunity ended, harms repaired, and decolonization achieved. They apply international law while conceptions of territory as victim that are grounded in diverse modes of knowing and being destabilize liberal humanist conceptions of victimhood, crimes, harm, and repair. This happens even if decolonizing moves occur through a well-critiqued politics of recognition with all its trappings and limitations. And even when it may not be possible to permanently destabilize Eurocentric understandings of nature, they remain prevalent in expanding rights-based frameworks, contributing to how we imagine justice with other than humans, place, territories, and one another. In this talk, I've tried to offer empirical and theoretical insights into the interactions between diverse grassroots victim organizations and institutional actors involved in transitional justice mechanisms during their ongoing attempts to widen the tenets of environmental and international law. These cases ask us to interrogate the profound challenges of defining crimes against nature and territories, while also signaling the limits of Western environmental-based categories for comprehending indigenous, Afro-descendant, campesino, and urban communities' differential relations to place and multiple conceptions of harm. I have also sought to demonstrate how ethnographic engagements with transition can produce a more humble, tentative social science that is speculative and invitational about the conceptual and ethical lessons an overtly transitional political situation can teach us, while also respecting the limits of anthropological writing on legally sensitive topics. Attempts to decolonize the country's transitional justice framework are hopeful, yet measured, propositional, and also constrained, radical, yet also bound to normative changes. It is no small proposition for a tribunal whose empirical and moral foundation is rooted in a liberal humanist framework of rights, attendant to a universal human, that, as Thomas argues, has difficulty in recognizing the gendered, sexual, racial, and civilizational inequalities sedimented over centuries, to acknowledge the legal personhood, kin relations, spiritual and living beingness of other beings who may also be casualties of war. Equally important is the Hep Chamber's attempts to expand legal understandings of territory in ways that trouble environmental agrarian, rural urban, and ethnic non-ethnic dualisms that have far-reaching political, policy, juridical, and everyday effects for the lives of the country's human and more than human dwellers. I do not suggest that a juridical-based solution will necessarily be capable of repairing the divisive aspects of multicultural constitutionalism, which resulted from arduous struggle on the part of indigenous and Afro-Colombian communities, while also reinforcing asymmetries and vulnerability among campesino, peri-urban, urban poor, and rural workers. An example of the ambivalence of decolonizing law through legal-based solutions is the fact that the marginalization and exclusion of certain populations reinstated by liberal modes of recognition is actively being addressed by now legally recognizing their territorial-based relations. It is yet to be seen how Colombia's differential transitional justice mechanisms will provide restorative justice options for not only crimes and harms committed against soils, forests, rivers, bays, mangroves, and mountains, but also the spiritual balances, existential integrity, and well-being of a multiplicity of bodies, spiritual beings, and forces. Practical attempts to legally recognize territories as victims come at a time when rights of nature frameworks and discourses of biocultural rights are emerging from the interpretation of multilateral environmental agreements, domestic and case law, shifts in development agendas, and the struggles of many grassroots communities. Multi-species justice studies have warned that current notions of climate justice, environmental justice, and legal bioecocentrism may be insufficient to overcome the persistent silencing of voices belonging to multiple others. These progressive legal terms may not question and thus implicitly condone human exceptionalism, and the violence of that liberal humanistic conditions of rights and concepts of rights have enacted historically and in actual attempts to redress ongoing social-natural harms. The HEP justices and legal teams who are part of life worlds where these critiques originated, or who are being confronted by processes that are decolonizing their formal legal training, show us the need to learn from the challenges faced by those who are working for justice from within, but of course not only juridical-based solutions, and the chambers of temporary tribunals. Thank you, that's my talk for today.
Thank you so much, Dr. Kristina Lyons, for your insightful talk and provocative analysis. I would like to open, we have a few minutes for questions. I would like to open the opportunity to people in the audience to ask questions. If you would like to either send a question in the chat, or if you would like to just unmute yourself, turn on your camera and ask the question. So. I guess I'm going to start with just a short comment. So my research is about the different understandings of peace in Colombia, and I am not surprised, but I find resonance with what you just presented of how the systems of relations between human beings and their territories, their ancestors, and their spiritual guidance and their spiritual forces form that concept of peace, and push and challenge the concept of, and the dominant concept and law of liberal peace, right? That has been applied throughout the globe and now in Colombia through the peace accord. Although, as you mentioned, the peace accord has important component called the ethnic chapter that has had the participation of Afro-Colombians and indigenous Colombians and campesinos. It was I would say limited, right, by the other negotiating bodies, right, of the accord. They are still pushing that concept of liberal peace, and so I just find that the kind of that parallel with your research about how the practice of communities like campesinos communities who are not recognized in the Constitution as bearers of specific or differentiated rights are pushing those kind of limits or those concepts of peace, of what is collective territory and who is a victim, right, and who deserves reparations. So I feel like it's a very interesting, a very inspiring parallel that I find and in your research, and that resonates with mine. So thank you so much for sharing all your insights. If anyone would like to send a question or ask a question directly, you're welcome. We have maybe 1 or 2 more minutes. So Lauren sent message saying there are a lot of similarities to the Maori move towards protecting rivers using the concept of legal personhood, but within an indigenous stewardship. I don't know if you would like to ask a question or if you would like to comment on something, Kristina.
I don't know if Lauren wants to say anything more about that comment. I can respond to it, but if they would like to.
Oh, thank you. No, I just that when I was thinking about this, I had done some study about, and here actually in New Mexico about using the kind of Maori idea in New Zealand of using these communities, these indigenous communities, as they were the original stewards of the land, to kind of take back power and using that in kind of on a national level. And I don't know if that could be applied in the same way, since in Colombia there's more conflict, and that's stemming into today's society. So I don't know. I guess I just thought of that, but yeah, go ahead and respond.
Yeah, no, I was just going to mention that the Maori case was very inspirational for the Rio Atrato, the first rights of nature case in Colombia in 2016. the lawyer and judges that worked on that case looked towards the case in New Zealand, as well as Ecuador, the Constitution in Ecuador, to build that, to build the kind of legal framework for recognizing the rights of the Atrato River. And really thinking with this biocultural notion of rights versus like the intrinsic rights of nature. Although that in Afro-descendant indigenous communities that were the demandantes of the case, that were actually never asking for the river to be recognized as having rights. They were asking for the state to implement the constitutional laws and the actual environmental regulation that exists in the country. That was the but the judge and the kind of legal team took the case into a different direction and wanted to kind of create this first rights of nature case in the country. But it was very much there's actually a few articles written by the legal assistant that was kind of the primary intellectual drive behind theorizing the rights of nature in that case, that's jointly written with a case in New Zealand. You might want to look at those articles, or if you're not already familiar of them. There's a couple. I can send you the information if you can't find it, but it's 𝗭𝗫𝗁𝗂𝗫𝗄𝗃 is one of the authors, and I'm not sure that it's co-authored articles, but he's one of the authors.
Thank you. Yeah, that'd be great to have more information on that. It's really interesting.
And if you're interested in thinking about, I don't know if you're particularly interested in rights of nature, comparatively thinking through different legal sentences, and if you are, like, I can also provide other suggestions about that. I also recently published a piece in Colombia, on in English soon this semester, I think, kind of critically analyzing the rights of the Amazon case and the implications that case had as it plays out in implementation in the region from a regional perspective. So anyways, but if you're interested in more about the rights of nature, I'd be happy to talk about that in another space and send you any references that I can.
Thank you. Yes, I'd be really interested.
Well, thank you so much, Kristina, for joining us today, and thank you everybody for attending. This is the end of our colloquium today, and I urge you to check the Department of Anthropology's website for the upcoming talks in the series. We have, I believe, 5 or 4 more in the semester. So thank you, everyone. Goodbye.
Thanks again, Pilar. Thank you for the